welcome everyone, our members and our guests to today's special extended lunchtime lecture. Australia holds itself out as a nation that adheres to the rules of war, the law of armed conflict and international humanitarian law. When our enemies fail to do so, we hold them to account. Regrettably, there are indications in the historical record, from the Boer War to the present day, of individuals wearing our uniform who have not complied with the rules of law, and indications of disconnects between formal orders and policy and local unit practices in relation to operations involving contact with enemy forces and civilians. When this occurs, in order to maintain our moral integrity and authority as a nation, which in turn gives us international credibility, strategic influence, and sustains our operational and tactical combat power, it is equally important that we apply the same exacting standards to our own military personnel. I'm sure all in this room will be aware of the allegations of war crimes being thrown around against Israel in the International Criminal Court, at the United Nations, and in relation to its conduct of operations in Gaza, and the accompanying use of information warfare and psychological operations, PSYOPs, designed to influence the opinions, emotions, attitudes and behaviour of opposition groups, and the very real impact that can have and is having on operations. As these recent events demonstrate, moral authority is an element of combat power. All the more reason for members of the Australian Defence Force and those who command our soldiers, aviators and sailors to be well trained and to be conversant with their responsibilities and obligations under the law of armed conflict, which for Australia is principally to be found in the Commonwealth Criminal Code. And on that note, on behalf of RUSI New South Wales, I offer a warm welcome to our two guest speakers. The Inspector General of the Australian Defence Force, Mr James Gaynor, CSC, whose responsibilities include the oversight of the military justice system that applies to all members of the Australian Defence Force, both during peace and in times of armed conflict, whether serving in Australia or overseas. And Brigadier Sean Parks, DSC DSM, who is the Deputy G7 Army at Headquarters Forces Command. Now, for those slightly less familiar with the Continental Staff System, just remind you that the G, of course, refers to an Army or Maritime Headquarters at divisional level and above, and the 7 refers to training. Brigadier Parks will be our first speaker, and he is well qualified to speak on his chosen topic, the rules of war, the Army training system. Brigadier Parks graduated from Duntroon in 1999 and was posted to the 2nd Commando Regiment, where he spent the majority of his regimental service. Brigadier Parks was the inaugural Commandant of the Defence Special Operations Training and Education Centre. He served as the Director Military Art at the Land Combat College and was responsible for Army's foundation and combat curriculum. Brigadier Parks' operational experience includes 2 deployments to East Timor, 2 deployments to Iraq and 3 deployments to Afghanistan. For operational service in Afghanistan, he was awarded a Commendation for Distinguished Service in 2009 as a Special Operations Task Group Plans Officer. In 2012, he was awarded the Distinguished Service Medal for leadership in action commanding a commando company in combat operations in Afghanistan. He was awarded the Distinguished Service Cross in 2017 for his command and leadership of the Special Operations Task Group Combat Advice and Assist Mission in Iraq. Please welcome Brigadier Parks to the podium.
Good afternoon, ladies and gentlemen. Thank you, Kim, for the introduction. It's a pleasure to be here today with Mr James Gaynor, the Inspector General for the Australian Defence Force. I'd like to commence by acknowledging the traditional custodians of the lands, air and sea in which we live, work and train. We pay our respects to the elders past, present and emerging. Also pay our respects to the Aboriginal and Torres Strait Islander men and women who have contributed to the defence of Australia in times of peace and war. Thank you all for joining us this afternoon. We appreciate the invitation from Mr Kim Turner, the President of the Royal United Services Institute of New South Wales, and an acknowledgement to our senior guest. Our presentation this afternoon will be in two parts. I'll address how the Army trains for war. Mr Gaynor will then address the role of the Inspector General of the Australian Defence Force in overseeing the implementation of the rules of warfare. My part of the presentation is on how the Australian Army trains for war, covers three areas. I'll begin with the discussion of the key factors driving Army's priorities. These include the government direction in the 2023 Defence Strategic Review and the 2024 National Defence Strategy and Integrated Investment Program, the ongoing work of the Royal Commission into Defence and Veteran Suicide, and the implementation of outcomes from the Inspector General of the ADF Afghanistan Inquiry. Second, I'll provide an outline of the Army training system and how we are evolving training across Army to deliver on government's requirements. Finally, as an appropriate segue into Mr Gaynor's part of our presentation, I'll describe how the Army training system incorporates an ethical behaviour framework to prepare our people for the challenges of military leadership and service. It's great to be serving the Australian Defence Force at a time when we have clear guidance and priorities, and that's been provided by government. The Defence Strategic Review last year was the most significant review of the Australian Defence Strategy since the 1986 DIB report. The DSR and the recently released National Defence Strategy are generation-defining documents that will shape the careers of our newest staff cadets and recruits. In the same way, the 1987 Defence White Paper did for today's general officers and warrant officers. To achieve the recommendation of the Defence Strategic Review and to meet Australia's developing strategic challenges, Government directed the Australian Defence Force to become a more focused and integrated force. The recent release of the National Defence Strategy and Integrated Investment Program on the 17th of April confirmed Government's direction to adapt Army for littoral operations by air, sea and land from Australia, and to build a world-class long-range land and maritime fires capability. We are undertaking the largest recapitalisation of Army's equipment in generations. This includes long-range strike weapons, advanced air and missile defence systems, proven battlefield aviation platforms, world-class armoured vehicles, and the largest and most capable landing craft we have ever operated. Of course, generating Army capability requires more than just procuring platforms. In the last 12 months, Army has made significant changes. These include reorganising our higher command and control to train as we would fight, strengthening Forces Command, the organisation I work for, ability to generate well-trained soldiers and teams, refocusing the role of our combat brigades and beginning to consolidating them in the north of Australia, focusing the 2nd Australian Division on Australia's domestic security and resilience, expanding the transformation of world-class battlefield aviation capability, and then finally raising the 10th Brigade in Adelaide to introduce long-range fires and air defence systems that will significantly enhance the support that Army can provide to our joint teammates. In addition to the Defence Strategic Review, the National Defence Strategy and the Integrated Investment Program, two other key factors that are shaping Army's priorities and our training are the implementation of outcomes from the Inspector General ADF Afghanistan Inquiry and the ongoing Royal Commission into Defence and Veteran Suicide. The outcomes of the Inspector General ADF Afghanistan Inquiry have a profound impact across Army. It's important to note that the alleged actions of the few cannot diminish the whole and the totality of the Army's 20-year commitment to Afghanistan. As an Army, we have and will continue to learn from our longest operational commitment. Army is committed to understanding and learning to become a better Army, and the Army training system has a critical role to play as we move forward. The Army training system will channel the lessons learned from Afghanistan, principally what our contributions has taught us about ourselves and about warfare in the 21st century. These lessons have and will continue to shape our doctrine, our training and our organisational approach. The forthcoming outcomes of the Royal Commission into Defence and Veterans Suicide have and will continue to shape the way in which Army operates. Our people and their families will remain a key focus for the Army. The Army training system is deliberately designed to support our people and teams to realise their potential. We know that good training empowers our people to succeed and develop their characters to support them to make courageous, ethical decisions. This brings us to the Army training system. Army's training system provides a foundation that enables the Army to generate land capability. The Army training system leverages the legacy and experiences of the past to deliver the fighting force of today, while preparing our people for the possible conflicts of the future. Government's direction to Army post the release of the DSR and NDS requires tailored adjustments to be made to the Army training system. In order to ensure our people are prepared for that next fight, and if required, we can scale our Army under pressure during times of crisis or conflict. The Australian Army has a rich heritage. We have always evolved our structures in our training system to meet the challenges of our strategic circumstances. This is not the first time we've focused on training for littoral operations. We can learn much from our littoral operations conducted in the South Pacific and Southeast Asia during the Second World War. With a DSR-defined aiming mark of 2030, the Army's training system is again focused on preparing individuals and combined arms teams to undertake military operation within Australia's immediate region, which encompasses the littoral and maritime approaches to Northern Australia through the Indian Ocean, Southeast Asia and Pacific Ocean. The Army training system continues to also leverage the lessons learned from past wars, as well as current conflicts in Ukraine and the Middle East, as we educate and train the officers and soldiers of today for the wars and conflicts they may encounter in the future. The recent organisational structure of Army Command and Control include the establishment of a 2-star training authority, the Army G7. The lead training, who will lead the training across Army, and that's my boss, Commander Forces Command General Susan Coyle. This appointment demonstrates Army's investment, commitment and prioritisation of the ongoing development and optimisation of our training system. Army achieves and assures operational readiness through the deliberate application of the Army training system. It is a defined system which formalises the critical pipeline that enables Army to scale under pressure for delivery of the land force the nation requires. The Army training system is designed to use the whole surface area of Army to deliver training. Our training establishments deliver the ab initio and periodic through-career individual training for officers and soldiers. Our units train to maintain individual skills, build teams and develop collective skills and experience. The Combat Training Centre, which is based in Townsville, and our major joint and partner exercise deliver advanced collective training which prepares our brigades and divisions as part of the integrated force to ensure it is ready for deployment under the Joint Force Employer, which is the Chief of Joint Operations, and that's General Bilton, based out of Bungadore in Canberra. Throughout Australia's Army's history, it has been the bailiwick of our military instructors to ensure that hard-won lessons are not forgotten and the standards of a professional Army are maintained. This has not changed. These same military instructors are also at the forefront of our continual innovation and improvement. Army's training system is only as good as the people that sustain it, and therefore we rely heavily on the experience that our military instructors gain through their postings between training institutions and the field units for individual and collective training. Therefore, to ensure there's continual investment in this fundamental training system, Army must strive to demonstrate its value proposition to the nation in order to recruit Australia's best and brightest. Army has a long history of leadership and ethics training which has informed and shaped the organisational culture and the values of our people. Our recent operations have highlighted the need to maintain and sharpen our focus on leadership and ethics training throughout our training continuum to prepare our soldiers and officers for the challenges of operations and for the future. This preparation for operations can only occur through the development of an inculcated ethical behaviours amongst our people. The Australian Defence Force has recently undertaken a journey to evolve and standardise the delivery of ethical behaviour training. The new Australian Joint Professional Military Education Continuum, known as JPME 2.0, aligns the delivery of joint professional military education and training and defines the learning requirements for all defence military and civilian personnel. JPME 2.0 forms the spine against which all three services align their education and training in pursuit of achieving professional mastery. Critical to Army ensuring its personnel act ethically and demonstrate ethical decision-making behaviours at home and in operations is the inculcation of defence values, character and culture, which are incorporated and delivered in pursuit of social mastery. JPME 2.0 seeks to ensure that every soldier and officer receives regular education and training along the learning continuum of their service, thereby inculcating the attributes needed as part of the profession of arms. Army will emerge from the shadows of Afghanistan, but not without change. The Army training system has already begun implementing the changes necessary to prepare our people for future military operations. The work of the Afghan Inquiry Reform Task Force has led to a number of important changes which are embedded through the Army training system. I'd like to highlight a few of these changes. Firstly, a significant program of work has been undertaken to reform the end-to-end training and education of character and ethics across the ADF. The Centre for Defence Leadership and Ethics, and that's based out of our Australian Defence College, has been critical in this reform, and this has seen the publication of CDF-led philosophical doctrine, which covers military ethics and character, baselining of the existing training and education provided against defence in ethics and character, development of distinct but complementary learning continuums for ethics and character, and development of a series of learning products to support the delivery of individual and collective training by groups and services. The approval of a new Laws of Armed Combat training policy, and the release of a Joint Learning Management Authority directive to the service training authorities. And this is to better align the design and development and delivery of LOAC across the ADF. By the end of 2024, an online learning hub for social mastery will be delivered via our online learning system and features e-learning modules for ethics, character and cross-cultural competence, as well as a library of vignettes. And they're really important in terms of how we learn from the past and using those operational vignettes for how we develop our people. Defence is also reviewing the pre-deployment support provided to senior commanders to ensure they fully understand the role of the International Committee of the Red Cross, so the ICRC, and the support the ICRC can provide to commanders once they are in country. Inherent to this is ensuring commanders understand their legal responsibility for ensuring LOAC training and the certification of the force prior to deployment. The Combat Training Centre, as described, which is based up in Townsville, that delivers routine and repeated advanced collective training for our units, brigades and divisions as part of the integrated combined force. They provide a practical example of how ethics training is being incorporated into training events. Scenarios in these complex exercises present ethical challenges to the exercising force and commanders, in addition to tactical challenges. Ethical decision-making is then deliberately reviewed, reflected and acted upon via the after-action review process. Through this process, Combat Training Centre mentors and coaches draw from the ADF ethics doctrine to facilitate key leaders and staff reflection on the following questions when making decisions. The first one is this lawful? What are the obligations and constraints this creates? What is my intent? Is the objective I intend good? Is it along with defence values? Have I evaluated my thinking? How can I reflect on my character and decision making? Thus, Army routine and repeated advanced collective training enables learning, driving improvement in the application of complex ethical decisions before our people are actually tested in war. In conclusion, it's an exciting and challenging time for Army and for the Army training system. Our people are at the centre of all that we do in Army. Leadership, character, ethics and cross-cultural training plays a key role in preparing our people to succeed in conflict. The Army training system will continue to evolve the training and education of our people to ensure that as an Army we are ready for the operational challenges of tomorrow. I'll now hand over to Mr Gaynor. I look forward to an opportunity for questions and discussions after this presentation. Thank you, ladies and gentlemen.
As Ron indicated, I think earlier, that we will have an opportunity to ask our speakers questions at the end of the presentations in a panel session, which will be moderated by David Leece. Now I'd like to introduce our second speaker, Mr James Gaynor, CSC, Inspector General of the Australian Defence Force. Now, in discussions in the lead up to the presentations today, James was keen to let me know that although I had retired from Army, I was still appointed as an Assistant Inspector General of the ADF, as that statutory appointment had never been revoked. A subtle reminder, I think, for me to watch my P's and Q's and be careful what I say.
Subtle.
Subtle? Less than subtle. James is a legal practitioner of some more than 30 years standing. Since 2003, he's worked principally in independent statutory offices related to military justice, including as Deputy Director of Military Prosecutions and Director of Military Justice Performance Review. He was appointed to the role of Inspector General on the 1st of December 2016. James is a former Army officer. His operational experience includes service in East Timor and in Iraq, where he was awarded the United States Bronze Star Medal. His 3 master's degrees in law, management in defence studies and public administration, and is an accredited public law specialist and a member of the New South Wales Law Society Specialist Accreditation Public Law Advisory Committee. As Inspector General of the Australian Defence Force, he is appointed by the Australian Government to oversee the quality and fairness of Australia's military justice system. So could you please welcome James Gaynor to the podium.
Good afternoon. Can everyone hear me at the back? Great. Well, I'd like to endorse the acknowledgement of country and Indigenous servicewomen and men that Brigadier Parks gave. I'd also like to, as the head of a national office, I'd also like to acknowledge the traditional owners of country throughout Australia. And I'd also like to acknowledge those current and former ADF members who are here in the room, including the Reserve. My office could not do its work without the Reserve. So I really appreciate members of the Defence Force Reserve. And I noticed that Sean's left me with plenty of time. 2 hours is nothing to me, so do get comfortable. And it gives me an opportunity to talk to you about with you about the development of the IGADF, its 21-year history, and its development as an independent integrity, assurance and inquiry agency. First, though, just before commencing to speak, David suggested that it would be useful for some people in the audience who don't have an understanding of the law of armed conflict to, if I was to just give a brief explanation of the law of armed conflict. And the law of armed conflict is a set of international laws, and international laws are established not by statute, like the laws that apply in domestic law are established, but they're established in 2 ways, either by custom, the custom of nation states and what they do, and in the laws of armed conflict context, it's what nation states do in warfare. And the other significant way, and more recently, more usual way, that laws of armed conflict and international laws generally are created is by way of treaty. So the first treaty laws of armed conflict date from essentially the 19th century. But in the 20th century, there was a lot of treaty work done to where countries, nation states, agreed that in warfare their troops or their armed forces would behave in a certain way. And a very recent example of such treaty arrangements is the Rome Statute of the International Criminal Court, which has established an international criminal court. It's what does what it says on the tin. But the way that such treaties are brought into from out of the international space and into domestic law is by way of legislation. And so when a country ratifies an international treaty, and it can be an international treaty on any subject, but when a country ratifies an international treaty, it basically legislates the terms of that treaty and creates laws in its own country to comply with that treaty and to implement that treaty's terms and provisions. In the case of the International Criminal Court, the Australian government in 2002 legislated the Rome Statute of the International Criminal Court. It had previously legislated the Geneva Conventions, probably the most famous or one of the most famous examples of international treaties creating the laws of armed conflict, and that they were part of the Geneva Conventions Act here in Australia. But in 2002, the Geneva Conventions Act and the International Criminal Court Treaty were incorporated into a division of the Commonwealth Criminal Code. And that Commonwealth Criminal Code that division is Division 268 of the Commonwealth Criminal Code, and it's that division that establishes offences in international armed conflicts and also establishes offences in non-international armed conflicts. These offences have extraterritorial application, which means that if someone is accused of having committed an offence anywhere in the world, they can be prosecuted in Australia. There are a series, though, of legislative requirements that need to be met before someone can be charged with an offence under Division 268 of the Commonwealth Criminal Code. Where this becomes relevant to my work as the Inspector General is that the military justice system, which is part of my jurisdiction and part of what I oversee, includes oversight of the investigation, prosecution and trial of offences under the Defence Force Discipline Act. Now, the Defence Force Discipline Act is an interesting piece of legislation. I could talk about it for hours, but I'd bore you, Richard. But it's an interesting piece of legislation because it includes what we regard as service offences, offences for being absent without leave or for falling asleep while on duty, but and also for low flying of military aircraft. But it also incorporates, it has a mechanism whereby if conduct would be an offence in the Jervis Bay Territory, then an ADF member can be charged under the DFDA if certain conditions are met. And this is the way in which the laws of Australia continue to apply to ADF members when they deploy overseas as part of a deploying force. So that is, in a very, very quick nutshell, a brief description of what the laws how we have laws of armed conflict and how they form part of Australian domestic law. Does anyone have any quick questions on anything I've just said before I proceed? I should warn you that I used to practice operations in international law, but it's a while since I have, so please don't make the questions too technical. Yes.
Why do we still have to have status of forces agreements with individual nations if we're all signed up to this?
Well, not every nation is signed up, and also the reason we have status of forces agreements is because otherwise, if Australia deployed its forces to a third country, then the laws of that third country would apply to the women and men of Australia's Defence Force in that country. And so the reason we have usually a status of forces agreement is to clarify the jurisdiction arrangements that will occur if someone is accused of having committed an offence while deployed overseas on operations. Is that a clear enough explanation? Great. Yeah, perfect, good. So to continue with my presentation, as you've heard, I was in the Army. I was a legal officer in the regular Army for almost 24 years. But before becoming the Inspector General of the Defence Force, I resigned all forms of ADF service. And I did that because I wanted to be absolutely clear that I had no future career aspirations in defence. And while I could bring my knowledge of defence and my knowledge of the Defence Force to bear in the execution of my duties as the IGADF, and that's the acronym I'll use from now on if everyone's comfortable with that, I wanted to ensure that I did not have any conflicts of interest or potential conflicts of interest in doing the role, and I wanted to be able to demonstrate that I would be absolutely impartial and objective in the execution of my duties. And as you've heard, I've been the IGADF for the last 7.5 years. Now, in this address, I'm going to talk quite a bit about the military justice system. I'll describe it in some detail shortly, but essentially, the military justice system means more than just the investigation, prosecution and trial of service offences. When I was a new lawyer in the Army, back in the early 1990s, when we spoke about the military justice system in those days, we ascribed to it the same meaning as is usually ascribed to the phrase the criminal justice system in everyday society. So when we spoke about the military justice system in those days, we were purely referring to the investigation, prosecution and trial of service offences, either in commanding officers' summary trials or in trials by court-martial or Defence Force magistrate. Nowadays, though, when we talk about military justice and the military justice system, we ascribe to it a broader definition, and that's because several parliamentary inquiries into military justice and an important review, about which I'm about to speak, into military justice said, yeah, the investigation, prosecution and trial of service offences is obviously part of military justice. But military justice also includes any process that the Defence Force uses which is intended for the good order and discipline of the Defence Force, but by which individual rights are also affected. In other words, if a process is intended for the good order and discipline of the Defence Force, but it also affects an individual ADF member's rights, or could affect an individual ADF member's rights, then it is part and parcel of the military justice system. So when you apply that broader definition to defence, or the ADF, then obviously the investigation, prosecution and trial of service offences is a process that's intended for the good order and discipline of the Defence Force, but individual rights are affected. People can be fined, they can be detained in the Defence Force Correction Establishment. Depending upon the seriousness of the offence, they can also be jailed. But also other administrative processes are included in the definition of military justice, and those administrative processes are which we include in the definition of military justice, and which my office therefore oversees, are the conduct of administrative inquiries in defence, not disciplinary or criminal investigations, but administrative inquiries, fact-finding into an incident or to find out what happened. The conduct of those inquiries is, of course, usually intended for the good order and discipline of the Defence Force, but it also has an impact on individuals. Individuals can be called as witnesses. In many cases, they can be compelled to give evidence, and so that's part of the conduct of inquiries is part of the military justice system. The taking of adverse administrative action against members of the Defence Force, giving them a notice to show cause why they should not be formally warned or censured, or their service in the Defence Force terminated, are all examples of processes that are intended for the good order and discipline of the Defence Force, but which obviously affect individual rights, because a formal warning or censure has an impact on an ADF member's consideration for posting and promotion, and also, of course, a termination of service has a big impact on an ADF member. And then finally, the handling of complaints by ADF members is a big part of the military justice system. Obviously, if an ADF member complains about a matter affecting their service, they have a right to ensure that their chain of command deals with that complaint appropriately. And so these are all part and parcel now what we regard as the military justice system. In terms of IGADF, although I'm called the IGADF, it's important to note that I'm a public office and any person can bring a matter to my office. Current serving ADF members, former ADF members, members of the public, family members of ADF members, can all bring issues to the office of the IGADF, and we will deal with them in the way that we assess and deal with other issues, with all of the issues that come. But in terms of how the IGADF came to be, I mentioned that we've been in business for 21 years. And to touch on IGADF's history, IGADF was born out of a time of crisis, it's fair to say. These are some of the headlines which in the late 1990s were published concerning one of Australia's premier regiments, and in which there were allegations of wrongdoing and failures of the discipline system, essentially, in that regiment. And the Chief of the Defence Force appointed a retired federal court judge, Jim Burchett. Can I just say that you know that when you're starting an inquiry with someone named Jim, you're off to a good start. But Jim Burchett, a retired federal court judge, undertook an inquiry into these allegations of wrongdoing, but also he assessed the effectiveness at that time of the military justice system. And he made a series of findings at the conclusion of his inquiry, and also recommendations. And one of his important recommendations was that there be an independent military inspector general, he said. There should be someone to do on an ongoing basis what I, Jim Burchett, have just done as an ad hoc activity, as a non-ongoing activity. And so the government adopted that recommendation. The Inspector General ADF was established in 2003 and became a statutory office in 2005. And as I've said, at the beginning, the IGADF was established to do one thing: to oversee military justice and to oversee the military justice system, to ensure that there was a balance between the ADF's arrangements for justice on the one hand and the individual rights of ADF members on the other. So, over the last 21 years though, IGADF's functions have expanded and additional responsibilities have been given to IGADF. It's important though to see the IGADF as an independent review agency and mechanism of the sort that governments, or the Australian government, has created to be independent review mechanisms. Other examples include the Inspector General of Intelligence and Security, the Inspector General of Taxation, the Commonwealth Ombudsman, and most recently, of course, the National Anti-Corruption Commission. So I mentioned that when IGADF first started, the role of IGADF was to look at military justice, but in July 2014, IGADF's responsibilities were added to include inquiries into service deaths. Now, such inquiries had traditionally been conducted within the Defence Force, and some of you will have heard of boards of inquiry or commissions of inquiry, and those were the types of inquiries that the Defence Force used to conduct into the death of an ADF member. A decision was taken in July 2014 to give that responsibility, to take that responsibility away from being, if you like, within the Defence Force activity, and to make it a responsibility of the IGADF, so that the inquiries that were conducted into service deaths would be conducted in a way that was completely independent of the chain of command. My jurisdiction does not include inquiries into the deaths of former ADF members, only currently serving ADF members. But my jurisdiction also includes inquiring into the death not just of full-time ADF members but also reserve ADF personnel as well. In addition to the responsibility for inquiring into the deaths of ADF members, in July 2014 IGADF was also given responsibility to superintend the redress of grievance system. Now, those of you who have a background in the armed forces will understand what a redress of grievance complaint is, but just generally, a redress of grievance complaint is an ancient right on the part of service members to complain about an issue affecting their service and to have that complaint appropriately dealt with. It is an ancient right. It was first legislated in connection with the English Armed Forces in 1717, and those laws became part of Australian law after they were adopted in Australia, and sailors, soldiers and aviators of the Defence Force continue to have a right to make a redress of grievance complaint, and it's a statutory complaint scheme. Once upon a time, they would complain to their commanding officer would inquire into it. After that, if the complainant was dissatisfied with the commanding officer's consideration of the complaint, they could ask for review by a service chief, and then a service chief would conduct such a review, also after having conducted an inquiry. This whole process took a long time. It didn't reflect on any of the commanding officers or the service chiefs that were involved, but it did take a very long time, many months on average, to deal with redress of grievance complaints. And so in 2014, a decision was made to make IGADF superintend the redress of grievance complaint system. Sailors, soldiers and aviators still complain to their commanding officer, but after that, after 14 days, I have an obligation to consider every complaint that's lodged as a redress of grievance, not just the ones where the outcome is dissatisfactory to the member, the ADF member, but also all complaints. So all complaints and the way that they have been dealt with are considered by IGADF and within my office. When it comes to, and then finally, the Minister or the Chief of the Defence Force can direct IGADF to conduct an inquiry into any matter affecting the Defence Force. So I have an own initiative inquiry power in respect of the military justice system, or anything arising out of a death inquiry or a redress of grievance complaint. But if it's a matter affecting the ADF, the Minister or Chief of the Defence Force can also direct IGADF to conduct an independent inquiry. Now, the Afghanistan inquiry, and I can't talk too much detail about the Afghanistan inquiry for reasons that I hope everyone here appreciates, because the work of the Office of the RGADF has now been taken on by the Office of the Special Investigator, and those investigations are ongoing. But the RGADF Afghanistan inquiry was essentially an inquiry initially into apparent failures of the military justice system. There were rumours and stories of wrongdoing by ADF members, and it appeared as though the discipline or the usual arrangements had needed to be reviewed, and so the RGADF Afghanistan inquiry commenced as an inquiry, if you like, into an aspect of the military justice system. But several months into the inquiry, the CDF actually directed an inquiry. The then CDF directed an inquiry into the matters that were under consideration by the Afghanistan inquiry. So that's an example of a CDF-directed inquiry. I mentioned that anyone can come to the RGADF and can raise a concern about the military justice system. We usually will not look into issues if the person who approaches us, or if the issue has not already been the subject of internal consideration by usual complaint or review avenues. So my office is very much an office of review. That does not mean I don't have the power to do investigations of serious matters, and sometimes someone will bring something to us, and even though they have not already used internal mechanisms or internal review avenues, we will still take it on and we will still conduct an inquiry. But sometimes we will say to someone, to a complainant, well, you haven't used this avenue, is there any reason why you can't? And then we say to them, try that avenue first, and if you are still dissatisfied, then you can come back to us down the track. It's a way of ensuring that they have a review mechanism that they can avail themselves of down the track. The reviews that my office conducts are merits reviews for the lawyers among you. We don't just do a review of the legality of decision making. We consider the facts, the law, and any applicable policy when we conduct our work. And if someone is dissatisfied with my office or the way that it has done something, then they can always complain to the Commonwealth Ombudsman, and so that becomes the Commonwealth Ombudsman's. That becomes their avenue of review if they are dissatisfied with what my office has done or the way that we have done it. So that slide describes the statutory arrangements for the work of my office. Importantly, you'll notice that there are two aspects, and I've focused very much on the inquiry component of my role and the investigation component of my role. But importantly, I also have an audit function as well. And so when it comes to assessing the way that the ADF operates and ensuring that its military justice processes are being correctly applied at unit level, that's where the military justice performance audits that my office conducts are very important. In terms of the inquiries that we do, my office is also responsible for investigations into complaints about the military police. So if there is a complaint about the military police or a complaint of misconduct or unprofessionalism, my office has a military police professional standards cell. And as I've mentioned, anyone can approach the office of the RGADF. We are small to do the work that we do. We have about just under 60 full-time staff, just over half of those are members of the public service. The other half are full-time ADF members. But we make, as I said at the very beginning, we make a big use of the reserve, and we could not do the work that we do in the reserve. A lot of the reservists that we use as assistants RGADF, and we've already had one self-disclosure in this room, but there are others. A lot of the reservists that we use have either had or have had careers in the full-time Defence Force, and then they have moved into the reserve on retirement, but it is so useful to have them engaged in the work of the office because they have knowledge and understanding. They know how defence works. They know which rocks to lift, for want of a better word. They are very effective in their role, and because they are retired, they have an interest still in making sure that the Defence Force functions properly and that members of the Defence Force are treated fairly, but they also bring all of that service knowledge to bear. So it's extraordinarily useful. In terms of the full-time staff at ADF staff at IGADF, they are really useful too, because every year I get a fresh injection of people with contemporary knowledge of how the Defence Force operates, what its processes are, and how different parts of the Defence Force work together, and that is so useful in terms of an oversight role. I think it's, the inclusion of such people in IGADF inquiries makes them far more effective than someone with no knowledge of defence might be. Now, I've already mentioned the Inspector General of Intelligence Security and the National Anti-Corruption Commission. In terms of IGADF's broader role, IGADF is an integrity agency under the National Anti-Corruption Framework in Australia. And the two pieces of legislation that are referred to in that slide basically allow the Office of the IGADF to work with the Anti-Corruption Commission and also to work with the Inspector General of Intelligence and Security. It's a way that we can share information, we can collaborate. It means that we can make more effective use of resources, and we can also make effective use of knowledge and expertise. A really important part of the work that we do, though, has always involved what is now known as a trauma-informed approach. Trauma-informed approaches are approaches which take into account the impact of trauma on the people with whom we deal. It's a concept that began in the 1970s in the physical health context, where hospitals in the United States particularly realised that they were far better off if they treated every person in that hospital as though they may have been traumatised in some way in the past. So it's a way of recognising that we will never understand the different life experience of the people with whom we interact. And so for many years at IGADF, we have taken into account the impact of trauma on the people with whom IGADF staff interact. That includes complainants, respondents and witnesses. In its practical application, a trauma-informed approach emphasises physical, psychological and emotional safety. And for this reason, at IGADF, when we do our work, particularly in the conduct of interviews, we try to conduct those interviews, witness interviews, at times and in locations where witnesses are going to feel safe and where they will have access to their support mechanisms, including legal support, but also, importantly, welfare support as well. Increasingly, too, we recognise the importance of aftercare arrangements, making sure that the work that the office does not just finish once we conclude a report or once we write to someone to let them know what the outcomes of their complaint have been, but that we continue to ensure that there are arrangements to ensure that that their welfare is considered, or that they have welfare arrangements in place. This gives you an idea of the nature of the complaints that IGADF receives in terms of the types of things about which people complain to my office. Now, these are just the military justice complaints. The administration complaints there, examples of an administration complaint, are where someone claims that an ADF member has been affected by failures in administrative processes related to the military justice system. The others are fairly self-explanatory. As you can see, unacceptable behaviour, bullying and harassment make up the bulk of the complaints that we receive. In terms of the inquiries that the office conducts, an IGADF inquiry is independent. I have statutory independence under the legislation that establishes IGADF. The military chain of command, that the Department of Defence cannot direct me in any way in the way that I acquit my statutory role and functions. Importantly, when IGADF conducts an inquiry, we look, not, as I mentioned before, not just at the legalities, but we also consider whether, yes, the process might have been lawful, the process might have been in accordance with policy that Defence has applied in the particular case, but we also look at whether that process has been fair in all the circumstances and whether we need to make a recommendation about changes to policy. I have no executive authority to change decisions. So I make findings, I can make recommendations, but ultimately it is for relevant decision makers elsewhere to decide whether or not they're going to accept those findings and whether or not they're going to agree with and implement those recommendations. But obviously, a recommendation from an IGADF inquiry report is a very compelling recommendation, and in the redress of grievance context, when I make a decision that a redress of grievance complaint has merit, then I'm obliged, under my legislation, to write to the complainant and to inform them that I have considered their complaint and I've considered that their complaint has merit. So that is also a compelling document for a complainant to take to relevant decision makers. But I have no executive authority to change decisions. We always offer what's known as procedural fairness. Essentially what I'm trying to achieve in every IGADF process is a sense of procedural justice. Not everyone who complains to my office will walk away satisfied with the outcome of their complaint. In other words, by which I mean they won't get they won't get a change in the decision that they were after. But what we do try to ensure is that people have a sense of procedural justice. That even if the outcome is not the one they wanted, they feel that someone who is independent and impartial and informed has investigated the issue that they raised and has then made a finding about the issue that they raised. So essentially what we're trying to make sure is that people feel that they have a sense of justice, that they have been heard and someone has taken them seriously and someone has looked into their concerns. As I mentioned before, the We don't make adverse findings. We ensure that we offer procedural fairness in all cases. We don't make adverse findings about any person without informing them that we are planning to make an adverse finding or that we are of a mind to make an adverse finding, and we ask them to comment on that draft adverse finding, and that gives them an opportunity to say, no, you've got it entirely wrong, or to provide other information that either modifies or changes that finding. And that's a very important part of any administrative inquiry that my office conducts, and we always ensure that we offer that procedural fairness step. It is a legal requirement, and RGADF inquiries are statutory inquiries which are always conducted according to law. And we can conduct inquiries in public or in private, because of the sensitive subject matter of most of our inquiries. Most of our inquiries are conducted in private, and we can compel evidence. We have broad-ranging evidence-gathering powers. In terms of service deaths, this is a crucial, a very important part of my jurisdiction. As I mentioned earlier, these were inquiries that were previously conducted by boards of inquiry and commissions of inquiry in the Defence Force. But obviously the purpose of any inquiry into the death of an ADF member is to ensure that any service-related factors in that member's tragic death are identified and appropriate findings and recommendations made to prevent recurrences or serious injuries. We focus on actions or inactions by Defence, and we also examine policies and procedures. Here is a slide that shows the causes of death in the last 10 years. We have a financial year reporting cycle, and we establish very constructive relationships with state and territory coroners. They still have jurisdiction into deaths of ADF members, of course. Nothing that we do removes their jurisdiction, but obviously the more collaboration we can have, then the better off everyone is, and the quicker we will get to the issues that we need to identify. I mentioned the audit function before. These are focused on the military justice system. Sean mentioned training before. We examine mandatory annual training as part of this audit program. We don't assess the training itself, but what we do is track the completion by members of each of the organisations that we audit, to ensure that those members, the unit is ensuring that members complete their mandatory training. Not all aspects of mandatory training, including unacceptable behaviour training, suicide awareness training, the full suite of training that ADF members must regularly undertake as part of being members of the Defence Force. When we conduct audits, we conduct them according to Australian standards. We want to make sure that the audit process that we use is going to deliver results that are informed by the best Australian standards for the conduct of audits. Each audit has 4 principal components. We have a lawyer go through the discipline paperwork of that unit, making sure that any disciplinary proceedings have been properly dealt with and have been the subject of proper acquittal within the proper dealing within the discipline system. I didn't mean to use the word acquittal there as meaning that everyone gets found not guilty. But we check the unit's use and application of the law and policy relating to the discipline system. We also use someone experienced in administration to check those other aspects of the military justice system: complaint handling, the conduct of inquiries, and adverse administrative action, formal warnings, censures, terminations. We ensure that the units have been compliant with relevant law and policy in relation to those procedures as well. The audit team speaks with specialists who support each unit, the ships, the battalions and the squadrons of the ADF who are undergoing audits. And we speak to the people who advise the commanding officer, the medical staff, the legal staff, and those who provide welfare and pastoral support, including the Padre. Our purpose in speaking to those individuals is not to find out the detail of individual cases, but to ensure that there is a proper dialogue and a proper there is proper communication between those officials and the commanding officer. And finally, we also deal with focus groups, or we run focus groups at each of the units, divided by rank and sometimes by gender as well. So the idea is that we will talk to a group of corporals from a unit in one hit. We will talk to a group of petty officers from a ship together. We invite them if they have issues that they don't feel capable of raising within the group context. We invite them to come and speak to members of the audit team outside of the focus groups. But importantly, what we are trying to achieve is a situation where members of that unit are spoken to in focus groups and can give frank assessments of what life is like at that unit and what life is like in terms of the application of the military justice system at that unit. The focus groups are a really compelling and powerful way that we talk to members of the Defence Force, and each year we speak to about 3 to 4% of the ADF population as a whole, and at the end of those focus groups we also get them to complete an anonymous written survey, and that anonymous written survey is also very useful in providing information to us about issues, emergent issues affecting the military justice system. And I'm almost at the end. Finally, there is an ongoing inquiry about which you may have heard, the inquiry into the tragic deaths of the 4 aviators who died last July. This is an important IGADF inquiry. It's headed by a retired criminal court of appeal, a retired court of appeal judge from Queensland, and also an Air Vice Marshal, Jeff Harland. The retired judge, Margaret McMurdo, is leading that inquiry, but that is an inquiry into the deaths of those ADF members. It is being conducted in both public and in private. It's an example, I raise it here because it's an example of an IGADF inquiry that is being conducted in public. Usually though, as I said earlier, because of the sensitivity of subject matter or for national security reasons, inquiries must be conducted in private. But we try to be as transparent in what we do as possible. So hopefully that gives you some idea of the role of the Office of the IGADF, its origins, and also the important function that it performs. And as I mentioned earlier, it is just one of several Commonwealth independent review agencies and mechanisms. It's the only one with a pure focus on the Australian Defence Force, and therefore, it's a very important function. But as I mentioned earlier, all IGADF processes, be it an inquiry, be it an audit, be it the handling of a redress of grievance complaint, are fair and are conducted according to law. Thank you.
Thank you. What I'd like to do now is just to hand over to Brigadier David Leece to facilitate the questions and to moderate the panel discussion. David, as many of you would know here, is chair of our special interest group on strategy and as a former president of the Royal United Services Institute for Defence and Security Studies in New South Wales. So David, I'll hand the floor to you.
Thank you, Mr. President. I would like to start, well, firstly, I want to thank both James and Sean for their presentations, and I'd like to thank you, James, for explaining a little bit about the law of armed conflict and how it relates to the International Criminal Court. And I wonder whether you might just drill down a little bit further into those comments you made. As I understand it, the law of armed conflict provides for the protection and humane treatment of both combatants and non-combatants, and the International Criminal Court both investigates and, where warranted, it conducts prosecutions against people who are accused, individuals who are accused of breaching the law of armed conflict. And the International Criminal Court does not replace the individual state jurisdictions courts if they deal with the matter, but it can complement them, or deal with matters if they don't address them. Could you just expand on that?
The lights turn green and you can hear me. So yes, thank you, David, for reminding me. The one thing I should have mentioned when I was talking about the International Criminal Court was the relationship of its jurisdiction with Australian courts, and that is, of the Australian legal system, and that is that the Rome Statute of the International Criminal Court, which is the treaty that establishes the International Criminal Court, sets out that the principle of complementarity applies. And what that means is that the International Criminal Court will only get jurisdiction to charge or try an alleged offender if a state party is unable or unwilling to investigate or try that alleged offender. So that's how the complementarity principle works. If the state is unable or unwilling.
Thank you, James. And there's another thing that I'd like you to look at, if you would, Sean. In your third last slide, I think it was slide 8, and also your second last slide, slide 9, you referred to the Australian Joint Professional Military Education Continuum. And as you focused on social mastery, and you mentioned emotional and social intelligence, and influence, military ethics and values, and character and culture. The strong emphasis over the last 20 years, which those of us who came from an earlier generation of soldiers have noticed, have gone on into ethics, which you mentioned in slide 9, I think is very valuable. But in talking to particularly people more of my generation, I guess, people who served in Vietnam and in similar peacekeeping and other operations overseas, 20 years, maybe 30 years after they were deployed on operations, they've come home and they've developed post-traumatic stress disorder, not as a consequence of anything that specifically happened on operations, but as they've looked back, and seen a disjunct between what their ethical principles were and what they saw happening. They may have been involved or they may have observed it happening but didn't do anything about them at the time. And this has caused great stress in their later lives. And I wonder if you could talk about what you observe in the current Army and how you deal with it.
Yeah, thanks, David. It's a great question, and it actually goes back to and the CDF's really driven this, what we call our philosophical doctrine. So there's 4 key pieces to that doctrine. The first one is leadership doctrine, and you go back through our history as a military, and you'd say, hey, the basis of our leadership probably hasn't changed too much. The character changes as you sort of move through society, and it changes. Character is the other centrepiece of that doctrine. Strength of character. And this sort of leads into the question you're asking. Ethics, massive one. A real focus, particularly on ethical decision making. And I guess, hey, we saw the Defence Force, some of those ethical issues in Afghanistan up here. But if you look to the current strategic environment, and you look at places like Ukraine and Gaza, how people are using unmanned systems, the use of technology, there's going to be profound ethical challenges our junior people will face beyond what we ever face. So how you develop them with that. And then the final piece of doctrine is the cultural aspect. So that's part of it is a little bit organisational culture, having a great culture as an organisation, but it's also the cross-cultural aspects of being able to work with partner forces, particularly in our region. So leading to your question, I think really what's emanated in the past is what people would describe now as moral injury. So when people have seen something and haven't been able to act on it, whether it's an ethical issue, that often results in moral injury, and it's led into post-traumatic stress. Through training and development, and training just doesn't solve anything, it's also experiential learning, but also, through good leadership, good character training, you're ethically trained, cross-culturally trained, hopes to arrest some of those potential issues. You'll never squeeze all the risk out of the problem, but there's been a real focus, and this is why it's philosophical level of doctrine that the CDF's generated.
Thank you, Sean. I'm now going to throw the panel open to questions, and I notice there are some already appearing. When you ask a question, would you please first state your name and your affiliation before asking the question, and please keep the questions short so we can have as many questions as possible. Ron's got the first one down here.
Thank you. My name is John Green. I was a former artillery and pay corps officer. Every couple of years we see in the paper claims of bullying, people being ill-treated, and they have since left the Defence Force without getting any joy or feeling their situation hasn't been handled effectively. I acknowledge the fact that you say that you can't handle anything from people who've left the Defence Force. My question comes with above, and that is, should your ability be widened to include those who were in the Defence Force, and if allowing that would overwhelm the IG or your department, does that have implications for the effectiveness of your office? And my apologies for a possible lack of tact.
Right. Yeah. Thanks very much for the question, and actually it seems it's I who must apologise, because my office can deal with complaints from former ADF members, so I'm very sorry if I gave anyone the impression that's not the case. So any person can come to IGADF, current serving members of the ADF, former serving members of the ADF, family members of current and former serving members, or members of the public, and they do. So one of the things that we do know in my office is that we, and have done for about the last 18 months, is that we actually, as part of our, we've been trying to increase our outreach, and Defence runs transition seminars for members of the ADF, and we have a stall, for want of a better word, at the transition seminars that Defence runs, and it's a way of ensuring that people who are leaving the Defence Force, they might never have heard of the IGADF, but it's a way of ensuring that there's another way for them to hear of us and to understand what we can do. And some of them say, look, I would never have done this while I was in the Defence Force, but now that I'm leaving or transitioning to the reserve, then I may well make a submission to your office. So once again, apologies for any confusion that I inadvertently gave. Any person can come to the RGADF.
Colonel Simidas is desperate to ask a question.
Thank you, David. Paul Simidas, RUSI. I got the feeling from the talks, I'm going to use the phrase prevention and cure. Army does a lot of good work to prevent what might go wrong, and the Inspector General's organisation provides some form of cure or adjustment. That's one point. The second thing is, it seems to me that if the chain of command doesn't operate well and technical control is flawed, then commanders give the wrong direction that is unsafe. That causes a lot of problems. What steps does Army take to ensure that chain of command is accountable, that technical control is effective and safety, and am I right that the Inspector General can address technical control issues and all those types of things that affect our service men and women in their training or operations? Thank you.
Yeah, I'd have to say, hey, the chain of command has not gone away. So there's still command accountability. We have the DFDA in terms of how we manage discipline, and that's used well in the main, I'd have to say. And then I have to say, hey, when you talk in the context of technical control, there's various other mechanisms the Chief of Army does to manage how we do business, particularly safety. We talked about land worthiness across our capabilities, and then how we manage our workforce is importantly, and I think Army it naturally does this as an organisation. Chain of command is really important. And then I guess, having an institution such as the IGADF just also provides the external oversight, transparency, and also the legitimacy of what we do. And you are potentially at risk if you self-govern, and I think having an external organisation that comes in and checks that we're doing the right thing is the right thing to do from a legitimacy point of view.
Yeah, and I guess that's where I mentioned that there are the two principal processes that we undertake. One of them is the inquiry aspect, but the other and really important one is the audit aspect, and that's where we talk to focus groups. And that the questionnaire that I mentioned asks questions of all ADF members who participate in those focus groups about their perceptions of the military justice system, but also their perceptions, their confidence in the chain of command.
Thank you, Brigadier. Atrocities in all wars make our focus on some of our special forces soldiers' alleged war crimes against individuals look to me unproductive. This follows on from Paul's question too. These crimes were clearly a failure of local leadership, but the ultimate responsibility rests with our High Command and the governments that sent our troops and hardware to that conflict. How can anyone be sure that airstrikes and missiles and artillery fire from over the horizon did not kill innocent civilians? can we use the wider lessons of war to end the plans for war crimes trialled in Australia? They go for years at great expense, diversion and for what gain? We certainly should compensate the families of the locals affected, but what's going to happen with these war trials, and is there a case to say enough's enough?
A typical government question, I think.
So as I mentioned earlier, there's very little that I can talk about specifically in relation to the Afghanistan inquiry. But the observation that I would make, and this will be really short, is that Australia has an obligation to investigate allegations and so it's very much not just it's a government it's not a government responsibility, but it's a national responsibility under all of the laws of armed conflict treaties to which Australia is a party to undertake that task. So it's look, there is much more that I could say, but which I ought not say, so I'll leave it there.
Thank you.
Major Hitchin.
John Hitchin, RUSI.
James, the question is, you talk about independence, yet on your establishment you show a large number of permanent defence lawyers and a lot of remotely reserve members. Do you select them, or are they sent to you by the system?
So that's a really good question, and the answer is not clear cut. So depending upon the seniority of the person, we basically choose the people. At the more junior levels, though, the services will say we plan to send this individual to you, and then we will undertake a vetting process is probably the best way of describing it, but essentially what we're after are people who are mature, who have a mature outlook and do not have anything in their background which would be inconsistent with working in an integrity agency.
Chris Skinner, board member of RUSI, former naval officer, and also former corporal in the Army Cadets at Adelaide High School. My question relates to cadets, which I think will be given increased recognition in the coming years. Firstly, does that fall within the IG's jurisdiction? And even if it does or doesn't, how does Army guide the training and education of such young people?
So to answer your question, Chris, very quickly, it depends. The wonderful thing about being a lawyer is that there are no clear-cut answers, and you'll never get just one answer. And also, I should just clarify one thing. My office only has a minority of lawyers in it. Most of the people that work in the office are not lawyers. We have lawyers in very strategic roles, obviously, to provide advice. But most of the people that work in my office are not lawyers. In fact, we've got a really broad spectrum of skill sets. Quite deliberately, we've got people with social work backgrounds, people with medical backgrounds, people with arms backgrounds. In terms of whether cadets fall within my jurisdiction, the short answer is no, but in those units where ADF members are, in those cadet units where ADF members are involved, then if an ADF member is part of a transaction, for want of a better word, or part of an issue, part of an incident, then that would be something that would fall within my jurisdiction.
Colonel Wolf.
Oh, we've got the other half of the question. Yeah.
Yeah, just in terms of the training, so observation, hey, wonderful thing, cadets, and in fact, we've got a really strong cohort here in Sydney that parade up at Vic Barracks, Sydney. So, you know, at the moment, you're probably reading the papers, Defence is living some pretty big issues in terms of recruiting and retention. Cadets for us are some deep recruitment in getting that right. So they are managed in Army by Director General Cadets, who works for the Deputy Chief of Army. We've got to manage cadets very closely because they're minors, so that's done very deliberately and through a system. But once again, I'd say, hey, really important part of our organisation because they are, in some parts, part of the future.
Colonel Wolf.
Or Special Interest Group. Brigadier, sir, could you just give the group a brief description of the Greenvale training facility and the potential that the sophisticated urban warfare training villages there will give the ADF the opportunity of a step change in this very complex and dynamic form of combat, and particularly in light of the problems in Gaza, how it will give ADF commanders from corporal to colonel a greater ability to make ethical targeting decisions.
Thanks for the question. So I think you mean Greenbank in Brisbane? The Greenbank facility?
Greenvale is more than Queensland,
so this is the
joint facility.
Yeah, so this is the urban facility you're talking about? Yeah. Yeah, well, there's two parts of this. One of the things Army's really focused on and has identified is the urban fight and having the requisite facilities, particularly live fire facilities, to do that. One thing I would say is you may recall the Private Chalice incident, which happened a few years ago. That was a death on a live fire training activity. That effectively put a stop to Army's training in the urban continuum until that was investigated and sort of particularly through what we call land range safety. So Army at the moment is on a regain for our urban continuum. That's a very deliberate process, and we're looking at all the requisite facilities of how we do that. I've spent the majority of my career in Special Operations Command. We've got some fantastic facilities on the east and west coast for that, and they're at the high end of the mark. For broader Army, the facilities up north are incredibly important. The ability to train up to a battalion level in live fire. To do that, it's got to be very deliberate. What we've also done is we've built a cheaper, more agile facility called the Dash, which is the deployable austere shoot house. The first of those is actually at Greenbank in Brisbane, and that's designed up to probably a section to go through and conduct urban live fire training. And that's where you can start to inculcate your ethical decision making in a live fire environment, and also use up to lethal munitions, but also non-lethal. Hopefully that answers your question.
Professor Howe.
I'm a immediate past president of RUSI and former infantry and armour officer in the reserve mainly. I have 3 points, and if you wouldn't mind, we are here to inform discussion and debate. So in that context, could you explain what the legal basis was for what appears to be to many of us an elephant in the room, which is that lower ranks have been found accountable for behaviour, mainly but not always special forces in Afghanistan or other operating areas, but senior officers of a particular rank and above have been recommended that they are not accountable. Now that's my version of what I've heard. Is there some legal basis that you could explain to us as to why that recommendation, which I understand came from a formal report, has been made? Because out here in the world of retired people, we're pretty puzzled by that. And it seems to us the chain of command goes right from the top to the bottom rather than finishes somewhere on an accountability basis. So that's my first question. The second one is, I was interested that in one of your slides you said that you can make recommendations but you can't change a decision. And I found that strange in one sense because, I mean, High Court judges are held up on appeal. People often say, well, you got it wrong, please fix it. Could you just explain why that power or that right was not given to you? and perhaps the reason for it. And the final one is that in my role as a professor, I've done a lot of police training, and the police have special status in law for doing certain things, like the right to kill given certain circumstances in law. Are we approaching a situation where we should discuss as a community giving soldiers that special status in law as distinct from just applying what I call peacetime thinking and logic to what happens in a wartime situation? I hope I've asked 3 easy questions.
Well, let's deal with the easiest one first, the first question. And once again, I do have to be very careful in the comments that I make, because the subject of the Afghanistan inquiry is
I understand.
Under investigation by the Office of the Special Investigation. And I don't really want to give an answer, but I can tell you where to look to find an answer, because the publicly available version of the report discusses this issue. It mentions that the leadership is morally responsible, but in terms of what that inquiry's purpose was, which was to assess rumours and stories of misconduct to identify whether they had substance, and then the inquiry itself made findings about whether or not there was credible evidence to support allegations. Bearing in mind, nothing is proved. So the publicly available report does set out in the legal, if you like, distinction's the wrong word, but it's the focus of that inquiry and its findings was on credible evidence which could support allegations of wrongdoing. But the report did say that, irrespective of legal liability, there was moral responsibility on the part of leaders. In terms of, and this is probably you asked 3 questions, and Sean will remember what they all were, but I might have a senior moment.
You're right to not change a decision, like you could recommend, but
yes.
you couldn't.
Yes. So, and that is something, that's a decision for government at the end of the day. But command is a very important. The only observation and comment I would make, and I don't want this to be interpreted as agreeing or disagreeing, but command is a very important part of service in the Defence Force, and it's a very important part of leading the Defence Force, and for the Defence Force to, a Defence Force, an armed force, it relies on its command relationships and the relationships that its rank and file have with their leaders. So there are, I think, while it might be appropriate in some government decisions for review bodies to have the power to change decisions, and the Administrative Appeals Tribunal is a good example of that, there are arguments which can be made about the importance of command, and therefore for a review body like the RGADF to merely to have the power to make findings, evidence-based findings, to make recommendations, but not ultimately to change decisions, because decisions about the ADF are decisions that, importantly, in which commanders have an interest, obviously. Great. And the third question?
The third one was that we have given a different legal status to police in a civil or non-military context. Yeah. And are we approaching, because many of us would think the Israelis do this under a black ops or Mossad and therefore don't test it. Yak, yak, yak. In other words, there's an informal system that says certain things are not tested. For police in New South Wales, they have different legal status and right for certain things, and we all accept that.
Yes. So it's very difficult to give an unnuanced answer, and it's very hard to answer a hypothetical question.
You might be considered becoming a lawyer then.
But so the laws of armed conflict do permit a member of an armed force to engage and target enemy combatants. The issue becomes when the laws of armed conflict are really there to protect. A lot of the laws of armed conflict are there to protect not just the people, the combatants on the battlefield, including the types of weapons that can be used. For many years, explosive rounds, for example, for over a century, explosive rounds have been unlawful according to the laws of armed conflict. But also to protect people who are sick or wounded or civilians or otherwise out of the fight. In other words, people who are non-combatants or people who are in French, and apologies to any people who speak French for my pronunciation, people who are hors de combat. So the laws do permit members of the laws of armed conflict do permit members of an armed force to apply lethal force in certain circumstances in a perfectly lawful way, but not in connection with people who are not combatants or are no longer combatants. Do you have anything to add? You don't have to.
No, just on the command accountability, it is a vexed issue. I'm not at liberty to talk to it. Less to say, I think the Afghan Oversight Panel is making some recommendations back to government on that particular issue.
The gentleman next to him.
Yes, I'm going to ask a question because...
name and affiliation.
They say that you should never ask a question that you don't have an answer for. But anyway, one of the issues that I've seen particularly... by the way, I'm a retired cadet officer. One of the issues that I've seen from the Afghanistan experience is that there doesn't appear to be any social or psychological profiling done on key people in the military, particularly officers or even commandos or SAS, given some of the issues that have been sort of raised in recent times. What are your thoughts on that? I find that that's something that's not easily handled. Psychological profiling is not something that the faint-hearted would enter into.
Thanks for the question. I think I'm actually well versed to answer it as a former commandant of a Defence Special Operations Training Education Centre. So I was responsible for the screening and selection of personnel into the Special Operations Command. I can tell you up front, the first thing that happens is psychological screening. A really important part of it. We also utilise attribute-based selection methodologies. Where the selection process is designed around activities that tease out attributes. A big one of those attributes is obviously ethical decision making. Humility is a new attribute we're actually selecting against. And when we do that, that is a combination of, on the selection course, having a psychologist on the ground along with a senior operator, viewing the candidates and selecting them against those attributes. It is a science and an art, that process, and that's evolved over a lot of years, and it's becoming increasingly more technical now we're doing in selecting people.
Thank you.
My name is Victor Bond, representing Talis today. My question is for Brigadier Park. My understanding is that Forces Command takes control of all of the reserve training institutions on the 1st of July. And at the same time, I previously mentioned there's ongoing rollovers throughout the year, sergeant, more and more captain. Where we're facing the difficult issues you raise about bringing more complicated decisions and those other types of problems. What kind of planning is Forces doing to ensure that the training continues to deliver that very high quality in-person training, noting that you're facing some real rank shortages across both sectors.
Yeah, thanks, Victor. Good question. So the 8th Brigade, which I know Brigadier Leece commanded a long time ago, will transition into Forces Command effective 1st of July. They have responsibility for all our university regiments, and in particularly a lot of our reserve training. So that's a very good outcome. And in fact, Forces Command are almost, as an organisation, trending back towards the old training command, which people may be familiar with. There's been some huge structural changes to the Army training system in the last 3 years, I have to say. One of those was the creation of the Land Combat College, and that's amalgamated what was formerly known as Headquarters Royal Military College Australia and in Canberra. And under that organisation now we have Kapuka, the 1st Recruit Training Battalion, for our Aberdeenshire soldier training, the Royal Military College Duntroon for our officer training, the Land Warfare Centre up in Canberra, which does all our promotional continues for our officers and soldiers. And then what was formerly under our Combined Arms Training Centre, School of Infantry, School of Armour, School of Artillery and Engineers. That moved, it was a deliberate move of putting all those organisations under one training authority, which is the Commandant, and that then gets after what we call our foundational continuum and our combat continuum. And that also has a curriculum and syllabus attached to all those organisations. In terms of training design, we're realising now that we're going to have to use technology a lot more. And when we talk about the concept of scaling, if you have to expand the force and army, how do we do that quickly? So part of it is, hey, there's nothing like the one-on-one instructor training that we do, and you'll never lose the requirement for live training, but also how we better use simulation technologies. And I've seen the value of that with our parachute school, having augmented reality training for how you don't have to hop in an aircraft, fly all the way up to 14,000 feet, jump out. Takes a bit of time, it costs a lot of money to actually do some of that training virtually, but then augment that with live training. And that's actually how you get your reps and sets quickly. So, in answer to your question, I think part of this journey is, hey, we've got to change our structures. We've also got to use technology better, and we've also need to work closely with industry. We've got a very good relationship with industry and particularly our TAFEs for our technical training. So this is our tradespeople. And that, instead of everyone having to come to a schoolhouse, say in Victoria, we can actually deliver some of that training all around Australia. And as I said, these are some of our initiatives that we've sort of umbrella on what we call Training Transformation Future Ready Training System, and it's now the Army Training System.
I now call on our President, Kim, to propose a vote of thanks.
Thank you. Can I, on behalf of RUSI New South Wales and those here today, just offer our thanks to both of you for your presentations to us today. If I can find a common thread that unites both presentations, it is the shared belief in compliance with law and policy and the pursuit of moral integrity, a commitment to ethics, character and culture in training, and a commitment to impartial, fair and independent inquiry in our military justice system. In the Afghanistan Inquiry Report, which has had some mention, I might add James in the public version of the report, so don't panic too much. It was said that those involved in the inquiry hoped that they would be able to report that the rumours of war crimes were without substance, and none desired the outcome to which it eventually came. But I can attest, free of any interference, the inquiry was free to pursue the facts and to independently examine the concerns that had been raised, and we should all of us should take great pride that there are very few nations in the world, I'd suggest, that would have taken ownership of its own problems and investigate them impartially, fairly and independently. So again, can I thank you for your thoughtful presentations, and could I just offer, by way of our thanks, an RUSI tie to Sean and a 12-month honorary membership of RUSI New South Wales. So thank you very much. And before people criticise me, where's mine, says James, where's mine? Obviously we'd make the same offer to James, but in the true spirit of his independence, of course, he would not accept either, which I fully appreciate and I greatly admire. James.
I appreciate the gesture. Please don't think I'm being ungrateful, but for the, as an independent officer or office holder, then I've had to gracefully decline.
So could you please join with me and thank Thank you very much for your support today. Please stay and have some afternoon refreshments with us, a glass of wine or an early glass of wine or some afternoon tea as we conclude this special extended lunchtime lecture. Thank you very much.